G'day everyone, it's Craig Pollard from National Baking Industry Association, and today we're going to be doing a presentation on the new Respect at Work rules that has passed the Fair Work Act, been introduced into the Fair Work Act, I'm sorry. Now these have been in place for a few months now, but I think it's time that we have a bit of a detailed look at exactly what these rules mean and how it's going to change the working dynamics in every workplace, because the major change that has been introduced is that sexual harassment is no longer just a civil complaint that an employee can make and then get damages for any or compensation for any damages they may have suffered. Now it's actually against the law, and employers and people who commit sexual harassment can now be fined. So let's jump in. So the background of this is that the Anti-Discrimination and Human Rights Legislation Respect at Work Act amended a couple of pieces of legislation, including the Anti-Discrimination Act, the Sex Discrimination Act, and the Fair Work Act. So the changes required is to provide better protection for workers from sexual harassment and other forms of sexual discrimination, sex-based harassment, which is a new critter, and unfair treatment in the workplace. Now, the purpose of this act is to move away from a complaint-based system, which basically means that it's reliant on a victim of sexual harassment making a complaint. So they have to make a complaint, and then the Anti-Discrimination Commission or the Human Rights Commission then attempt to resolve a settlement, and if they can't get settlement, then it has to proceed to the federal court where that complaint can be dealt with. Now it's made the act of sexual harassment unlawful, and it has essentially automatically made an employer guilty if their employee commits sexual harassment, and we'll get to how all that works in a second. So key changes. So this all came into place from 6th of March, okay? It's unlawful to subject another person to a workplace environment that is hostile on the ground of sex. And that hostile work environment is sort of we're importing that from the United States. It started to be recognized or considered in decisions for a few years now, but it's now specifically unlawful to have a hostile work environment that is based on sex. So it's a PCBU. Now, a PCBU is an important concept that you need to remember. If you've ever had any dealings with workers' compensation or the Work Health and Safety Act, they refer to PCBUs, or persons carrying out a business or undertaking. So that's person running a business or owning a business, okay? The person who is operating the business is a person carrying out a business or undertaking. And so it is the PCBU who bears the responsibility here. So you've got to take reasonable and proportionate measures to eliminate, as far as possible, certain discriminatory conduct, including sex discriminatory conduct, sexual harassment, sex-based harassment, and certain acts of victimization. So certain acts of victimization relate to victimizing somebody who's made a complaint. So if somebody makes a complaint and says, Bob's harassing me, and you say, well, I much prefer Bob than you, and how dare you make a complaint? You're fired. I don't have whiners in my bakery. That is a crime, and it's actually now punishable by prison time. And there is a lower threshold for what's now called sex-based harassment that requires the conduct to be only demeaning rather than seriously demeaning, okay? And there's always argument about how serious is the word serious. How important is it? Well, in this case, it is quite important. So what is sexual harassment? Well, we've been around a long time now, so I don't think it comes as any great shock as to what sexual harassment is. So we'll fly through these, but feel free to pause the video and have a good look. But Unwelcome touching, staring, it should be staring, or leering, a suggestive comment or joke, sexually explicit picture or poster, unwanted invitation to go out on dates. How do we know it's unwanted? They've said no already, okay? You can ask somebody out once, but you can't go back for more if they've already said no. It's that straightforward. A request for sex, any request for sex for somebody at work, there's no circumstance where that is going to be anything other than sexual harassment. Intrusive questioning, unnecessary familiarity, such as deliberately brushing up against a person. And we'll get into the design of workplaces a bit later. I know it's difficult in bakeries because particularly the production area and the service area in the front of the shop, it's always very tight. But we're talking about where somebody goes out of their way to make it very clear that they're not just trying to squeeze past. This is not just a, look, I'm sorry, I've just got to get past you. It's a chance to have some fun. All right. So that's just not on. An insult or taunt of a sexual nature, sexually explicit emails or messages, and that could be also leaving notes around the bakery, leaving notes around the workplace, that sort of stuff. And sexual harassment can be a single incident. It doesn't have to be repeated. That's an important point. So what is sex-based harassment? Well, it's a bit different. Sex-based harassment is where someone subjects another person to unwelcome conduct of a demeaning nature and does so because of the person's sex or a characteristics that is generally imputed to persons of that sex. Well, what does that mean? Well, it occurs in circumstances where a reasonable person would anticipate that the person harassed would have been offended, humiliated, or intimidated by the unwelcome conduct. Now, what is a reasonable person test? A reasonable person test is somebody who is reasonably intelligent, not associated with your business, but just looking in a window, who can overhear conversation, who can see what's happening, doesn't know the workplace, doesn't know the dynamics, but looks at a situation and goes, my God, that's inappropriate. That's basically what you're talking about, okay? So it's not somebody who is interpreting a long-standing relationship or working relationship. It's somebody who's looking in a window, looking at it, going, God, that doesn't look right. That looks wrong. That's your reasonable person test. And yeah, it's not a moron in a hurry going, oh, I don't know what's going on. And it's not somebody who is deeply involved in the workplace who can interpret people's looks and emotions based on previous interactions. So the relevant circumstances that have to be considered include attributes of the person, the relationship between the person harassed and the person engaged in the conduct, any disability of the harassed person, any power imbalance. And oh my God, this is so important. Okay. Anytime you're a manager or an owner and you're interacting with an employee, that dynamic, that power dynamic between an employer and an employee is incredibly important in determining whether or not conduct is sex-based harassment or sexual harassment and whether it is not. The seriousness of the conduct, whether the conduct was repeated. So sex-based harassment may not be a single incident. It could be a repeated pattern. So something could be innocent and once off, could later become a pattern of behavior that is then clearly sex-based harassment. Any other relevant circumstance, and by any other, by all means, understand it's any other circumstance. So you basically, it's the court that decides what is going to be considered, okay? And that the conduct occurs in a workplace or within a working relationship. So it doesn't have to be just in the bakery. It can be the workers, they all go out to a pub afterwards or at a Christmas function or something like that. And as long as it's a work-based environment, you're there because you're at work or because you're working together, then it could well be falling into this realm. It does not include circumstances where people are mates and they go back to somebody's house and they're just hanging out, right? It's not a work function. That's got nothing to do with work. They just happen to know people through work. We're talking about circumstances where it's organized as part of a workplace function. Okay. So Some examples of sex-based harassment: asking intrusive personal questions based on a person's sex. So things like, when's your period due? Or are you on your period? Is that why you're so grumpy? That's sex-based harassment. Okay, it's gross. Making inappropriate comments or jokes to a person based on their sex. Displaying image or materials that are sexist, misogynistic, or misandrist. So, I don't know, I guess anything by Piers Morgan. Sorry. But articles, centerfolds, anything like that posted up. Some article about from some right-wing nut job who's saying that they're alpha males and women need to be kept in their place. I can promise you that will be sex-based harassment. Making sexist, misogynistic, or misandrist remarks about a specific person. Requesting a person to engage in degrading conduct based on their sex. So it doesn't have to be sexualized conduct. It can just be degrading conduct based on their sex. So, it could be, you're the woman, go and make us the coffees. Sexual harassment legislation protection applies to the following classes of people. So employees, contractors, work experience students or interns, an outworker, small business owner who works in the business, apprentice or trainee and volunteers, future workers, so people who come in for a job interview, it covers them, and people conducting a business or undertaking. So they're the people that this applies to. So it doesn't just protect everyone there, but it also holds everyone there responsible for their behaviour in the workplace. That's the purpose of the legislation. So what do? How do you meet your new obligation? Well, you have to investigate sexual harassment and discrimination claims or complaints, right? You can't just ignore them. You have to take them seriously. So you have a duty of care to protect your workers from sexual harassment. Under the Fair Work Act, a person or company may be liable for sexual harassment committed by an employee or agent in connection with work, including if they're involved in the employer's contravention. This will apply unless the company can prove that they took all reasonable steps to prevent the harassment, okay? That's going to be a very high bar for you to pass. Now, if you're found to be in breach of these laws, it could result in penalties such as fines, as well as compensation to the victim. Now, the big change here is it's no longer waiting for the victim to make a complaint and then the commission deciding, oh, well, I'll apply compensation and now I've got the ability to award penalty units against you. That's not what it is. What it means is organisations such as the Human Rights Commission now have the same powers as the Fair Work Ombudsman to go out and investigate breaches of these laws. So you could be approached by an officer from the Human Rights Commission who has received a complaint from an employee saying I'm being harassed in my workplace. And this officer could go out and investigate whether or not your workplace is endemic for this behavior, and then you could be prosecuted. You could be prosecuted if this person is being sexually harassed and it's not endemic. But I would suggest that a prosecution would only be likely in circumstances where they can see that A, you've done absolutely nothing to try and get ready for this change, and B, that they've made a complaint and you've ignored them. Okay, so I wouldn't be too concerned about prosecutions unless you are completely rejecting the very idea that people can be sexually harassed. If that's the case, then look forward to your new future, because it's going to involve fines and possibly the loss of everything. If you accept the fact that people can be sexually harassed and it can have a devastating impact on people, and you have a role to investigate and take these matters seriously, I don't believe you will be fined. Okay. So what is a hostile work environment? Well, this is a newbie. So the Fair Work legislation definition of a hostile environment is where a reasonable person testing is done. And is there an anticipated possibility of the conduct resulting in a workplace that is offensive, intimidating, or humiliating to a person on the grounds of sex? So we go back to that reasonable person test again. Again, it's not a moron in a hurry. It's somebody who's reasonably intelligent, standard got person in the street, not man in the street, person in the street. Looking in your window, maybe observing the workplace and seeing what's going on. If they see posters on the wall that say, you know, go get me a sandwich, and a picture of a woman with an apron, or nudie photos, or guys walking around with inappropriate t-shirts and saying inappropriate things to women, well then, yeah, it's a hostile work environment based on the grounds of sex, and you're going to be in an awful lot of trouble. If a person considers that they are subjected to a hostile workplace environment, they can lodge a complaint with the Fair Work Commission, and that's where they go. So the Fair Work Commission process is that it's very similar to the bullying jurisdiction. So the anti-bullying jurisdiction is an employee can make a complaint to the Fair Work Commission. The Fair Work Commission can call a conciliation conference, try to resolve it, make recommendations, but that's all they can do. They can't make an order. They can't say this person's lying and that person's telling the truth. They can't say that sexual harassment is definitely happening. All they can do is try and resolve it. It is then up to the employee, if nothing happens, that the employer doesn't comply with anything or doesn't agree with anything, doesn't accept what the commission has said, then the employee can complain to the federal court. Okay, so that's that process. I don't know that there's going to be much of these claims. I don't know that they're going to be a major thing. Certainly there will be a very strong focus from plaintiff law firms on sexual harassment complaints in the Human Rights Commission. Now that they've got these added penalties, they've got a whole lot more money that can be paid to employees, and then they will get a percentage of that, right? So that's where they're going to target. I don't see that there's much call for the hostile workplace environment unless it's a very large workplace and they can do a claim of a number of employees, right? In which case the damages will be extrapolated out. So that's pretty much, I think, the way it'll go. So what's the responsibility of a PCBU? PCBU must eliminate or minimize health and safety risk of workplace sexual harassment as far as reasonably practicable. So this does not replace your obligations under the Workplace Health and Safety Act, okay, or workplace health and safety legislation. This is on top of. You should manage it like you would any workplace health and safety risk. So just the same as we put safeguards on dough sheeters so people don't, you know, apprentices normally would ram their fingers up for no good reason. Same thing here. You've got to put guards in place. You've got to put systems in place. You've got to put processes in place to make sure your staff are protected from this sort of treatment. It is not enough now to say, if something happens, come to us and we will resolve it. You must now put protections in place to prevent it happening. Okay? And so that includes control measures. It includes hazard, what do you call it? Risk analysis. And so it could be that, you know, you've got Bob and he's always been a bit sleazy. And, you know, he's always been a bit huggy with the girls, but you managed it by telling the girls before they start, you know, watch out for Bob. He gets a bit huggy. Just if he gets too much for you, watch out, come and let me know. Well, now, I think you're just going to have to fire Bob. I'm sorry. There's no place in the workplace for Bob while he continues to act like that. And we can't keep saying to women, look, just let me know if he gets too touchy, okay? Bob, no touchy, full stop. It could be that you need to redesign the workplace a little bit. And this is tough, all right? I'm not saying it's easy because I know, I've worked in bakeries, they're small, okay? And you've got minimal, pardon me, minimal area to play with. But I also remember that there were things like the uniforms that girls used to have to wear, and they were see-through. They were always white, see-through uniforms. I don't know why. It was considered that that was the normal uniform back in the 80s and 90s. But the fact is that maybe that's one step, making women feel more comfortable, making women feel that they're not going to be leered at by people when they're working behind them, right? So it could be that's one step. It could be that you have people facing each other in the factory rather than one working behind the other. Who knows? It depends on what you see as being the risk and doing a proper analysis of it and consideration of it, and then taking the required action. It's also imperative that you revise your policy. So we've now got a new respect at work policy, or sexual harassment policy, that we've uploaded to our website. It's imperative that you have a policy similar to that, if not that one, that complies with the amendments to the legislation. So it's a more positive action that you've now got. It reflects the sex-based harassment, and it offers more avenues for people to make complaints other than just one person, particularly if that one person is the alleged harasser. So it's always good to have multiple avenues of complaint for an employee. Okay, so stopping sexual harassment in the workplace. Look, this is a social problem, right? It's not just a workplace problem, but unfortunately we have to deal with it in the workplace. And we have to deal with the fact that women have been conditioned from birth nearly to put up with men's crap and the way they misbehave. So we now have to try and not resolve that social problem, but prevent that social problem walking through our doors in the workplace. That's our job. We're not going to change Bob. What we can do is we can lock Bob out of our office, out of our bakery. We can say, I'm sorry, Bob, there's no place for you here. We now need people who are willing to work together as human beings and not lechers, okay? That's what's necessary. And you could manage the workplace to prevent sexual harassment by providing safe physical and online working environment, as I've described just recently, providing information, instructions, and training to staff to prevent and address sexual harassment in the workplace. A proactive approach to address unwanted or offensive behaviour early, and encouraging the reporting of sexual harassment and having an effective complaints procedure in place. Now, a proactive approach to address unwanted or offensive behaviour, what that means is you don't wait for Julie to make a complaint. If you see Bob doing something that is not appropriate in the workplace, you don't wait to see if Julie's upset about it. You go over and you say, no, that is not acceptable. All right. Now, unfortunately, some of these people, I would really like to be able to treat them like misbehaving puppies and smack them over the nose with a wet newspaper. We're not allowed to do that, sadly. But we are able to take disciplinary action. So if you see people conducting themselves in a way that is inappropriate, then it's on us as employers to go up to them and say, this stops now and it's not acceptable. And you do it in front of Julie and show Julie that you will not tolerate that behavior, so that if it happens again when you're not there, she knows to come to you and say, look, he did it again. If it happens when you're watching, even worse is happening when you're not watching. So you've got to act. If Julie comes to you and says, look, I'd like to talk to you about, I just want to get off my chest. I don't want to make a formal complaint because I don't want to make things hard, but this has been happening. She's just made a complaint. Okay. You are not obligated to keep it quiet. You're not obligated to keep it confidential. You're not obligated to respect her wish to not take it further. You're obligated to protect all of your staff, not just Julie. And if Julie is a victim, I can promise you Julie is not the only victim. So it's your job, it's your obligation under this legislation to take steps to prevent this behaviour from occurring again to Julie or at all to any other staff member. So as soon as Julie stops talking and you stop writing notes, you start investigating and you say, thanks, Julie, you have our full support. I will make sure this never happens again. That is your obligation. If you do that, you'll be complying with the legislation. So what are the penalties if you don't? Well, okay. Now, it could be, I don't actually set out the dollar figures here, but there's a number of problems for you. The fines for a corporation, so that's a Pty Ltd company or association, could be up to $600,000 maximum fine. If you victimize people, it could be 12 months in prison, plus huge fines. For individuals, up to $60,000 fine. That's not just the employee who commits a sexual harassment. That is an employer who allows it to happen. So it could well be that a manager who sees this behavior and permits it to occur is also guilty of a breach of this legislation and is also liable for a personal fine of up to 60K. And it's 60K for each offence. All right. So whilst a course of conduct is not one particular one, is not a bunch of different offences, if you've got an offender against 2 or 3 different women, you've got 2 or 3 different offences. And so these fines, they rack up. And that's before we get to the compensation, right? So the amount of money we're talking here is not insignificant. And we know it's a risk. We know there's significant risk of these fines being implemented because we've seen recent fines, for example, breach of underpayment of wages legislation. So if you don't pay your staff, you could be fined up to $240,000, $300,000. And we've seen these fines issued, and they're almost routine now. Well, given the fact that the compensation being awarded to victims of sexual harassment, rape, sexual assault, and so on in the workplace have been growing exponentially over recent years. We saw that massive settlement from David Jones in the millions. We've seen other cases where the compensation is in the hundreds of thousands of dollars now, whereas only a matter of 10 years ago, it was maybe $15,000 or $20,000 for the most significant case of sexual harassment. You're now looking easy 6 figures for compensation. So you've got compensation for the victim, you've got the penalty issued by a court, and those penalties, they come with a sting in the tail. There's no way of getting out of paying them. You can't just go bankrupt and say, I'm not paying it. You'll end up paying it. So for the love of God, what we're saying is pay attention to these changes, implement the policies, do what you can as a business to get in front of this, because the last thing we want is to see bakeries on the news because somebody thought they were just being a jokester. The manager said that's the way Bob's always been. And Bob always says, oh, she always laughed and always, she joined in and thought it was funny. No, Bob, she didn't think it was funny. She was laughing because she wanted to keep her job. Okay. Even and another whataboutism that is raised is, oh, but what about when the girls are just as bad as the guys? Stop it. It's not the place for it at work. Maybe back in the 50s, maybe back in the 70s, look, even in the 80s and 90s. Not now. It's 2023. These laws have been introduced, and that stuff stops now. Has to. There is no choice. All right, so that's pretty much it for me. Thank you very much for paying attention, for joining me today. As always, very happy to, sorry, just came off that. Very happy to be part of your day, and hopefully you've learned something. Hopefully I haven't freaked you out too much. That's not the idea of these, okay? I'm not here to scare people. What I'm trying to do is make it clear that there are options available to you to address these changes in legislation, that we have resources available to members to be able to make sure that they are as free of risk as possible. And for the love of God, don't hire Bob. But other than that, as always, if you've got any questions, please give me a call. Available through the NBIA IR hotline, or shoot me an email at ir@nbia.org.au. All right, until next time, thanks very much. Catch you later.